Hello, my name is Alex Proctor. I'm the Chief Trust and Privacy Officer at Captain Compliance. I'm recording this video in late December of 2025. It's almost New Year's, which means we're very close to seeing a bit of a shakeup in the US privacy regulation landscape. January 1st is actually going to be a very meaningful day for privacy compliance here in the States. We have brand new privacy laws in Indiana, Kentucky, and Rhode Island, all taking effect on January 1st. We also have multiple privacy law amendments going into effect, universal opt-out requirements activating, a right to cure expiring, and a statewide consumer opt-out system going live in California. All of this on the very first day of the year. There's a lot to keep track of here, so if you're responsible for privacy compliance, legal risk, or marketing practices, this video is for you. Now, normally when I do these types of videos, I tend to focus on one thing at a time, and I like to go pretty deep. I released full-length videos for Tennessee's TIPA and Minnesota's INCDPA this year. I even live-streamed a webinar for Maryland's MODPA, because that law is so unique and stringent compared to many of the other state privacy laws that have passed. This video, however, is going to be a little bit different. It's more of an overview of several changes across a couple of states that you should be aware of heading into the new year. I'll be bouncing between topics and focusing primarily on key updates or unique aspects of the laws that I'll be talking about. In other words, this may not be the most thorough introduction if you're completely new to US privacy regulation. This is really about what's new in the new year. So with that said, it makes sense to start by looking at the brand new consumer privacy laws and the types of businesses that they apply to. Let's start by checking in with the Hoosiers. The Indiana Consumer Data Protection Act, or the INCDPA, is the first of three new privacy laws that take effect on January 1st. Like the majority of the state-level privacy laws, it includes applicability thresholds that determine which businesses are covered. The INCDPA applies to companies that process personal data for either 100,000 consumers or alternatively 25,000 consumers if more than half of the company's revenue comes from selling personal data. When you compare the primary 100,000 consumer threshold to Indiana's population, it works out to about 1.44% of the state's population. I'm not sure if you'll find that useful, but I like to think about these thresholds in percentage terms because it allows for more meaningful comparisons from one state to the next. Like the other state privacy laws, the INCDPA provides a standard set of consumer rights. These include rights to access, disclosure, correction, deletion, and portability. It also includes the right to opt out of targeted advertising, the sale of personal data, and certain types of profiling. There's nothing particularly unique here. These are the typical consumer privacy rights that we see across the US. Indiana's law can generally be described as being business-friendly, especially when compared to some of the other state privacy laws. I'll give you a few examples of why that's the case. First, the INCDPA does not require businesses to support universal opt-out signals. This sets it apart from many newer laws that do require support for standards like global privacy control. Second, the law is very restrained in how it defines the sale of personal data. While many states have adopted broad definitions, Indiana limits the concept of a sale to monetary transactions only. I'll explain why that distinction matters more when I cover Rhode Island's new law. Next, Indiana offers a narrower right to correct than most other states. In Indiana, this right applies only to correcting inaccuracies in personal data that the consumer previously provided to the controller. This leaves broad categories of data out of scope, including inferred data, data obtained from third parties, and internally generated data. Indiana's right to correct does not apply to those categories. Another area where the INCDPA is more limited is its definition of sensitive health data. In Indiana, sensitive health data refers specifically to personal data revealing a mental or physical health diagnosis made by a healthcare provider. What this definition does not include are the broader categories of consumer health data that other states are beginning to regulate. For example, Unlike in states such as Connecticut or Maryland, data generated by a wearable fitness tracker would likely not qualify as sensitive health data in Indiana. One final point worth mentioning is that Indiana's law includes a permanent 30-day cure period, which is something that most states are moving away from. This gives businesses a short window to address violations if the Indiana Attorney General identifies an issue. Before we move on, I also want to briefly touch on exemptions. Like most privacy laws, the INCDPA includes a number of industry and data-based exemptions. The standard exemptions apply here. Certain state entities, nonprofits, and higher education institutions are all excluded, as is healthcare information regulated by HIPAA and financial information regulated by the GLBA. There is, however, one unique exemption worth calling out, and that is facial recognition systems used by riverboat casinos. It's an unusual carve-out, but it highlights how state privacy laws are often shaped by local political and economic priorities. Next up, let's cover Kentucky and the KCDPA. This law also goes into effect on January 1st. The Kentucky Consumer Data Protection Act uses the same applicability thresholds as Indiana does. However, because Kentucky has a smaller population, the threshold is proportionally higher. That 100,000 consumer threshold represents about 2.18% of Kentucky's population. So even though the threshold looks identical on paper, it's effectively higher in practice. The KCDPA is another very business-friendly law that mirrors several aspects of Indiana's. I'll give you a couple of examples of where the two laws align in terms of their business friendliness. Like Indiana, Kentucky chose not to require support for universal opt-out signals, such as global privacy control. Kentucky also adopted a narrower definition of what constitutes a sale of personal data, limiting it to monetary transactions only. Finally, Kentucky included a permanent 30-day cure period, just like Indiana did in its state law. I should also mention that, like Indiana, Kentucky requires businesses to conduct data protection impact assessments for processing activities that present a heightened risk of harm to consumers. However, Kentucky has delayed this specific requirement until June 1st of 2026, giving businesses a bit of extra time to put their DPIA processes into place. When it comes to exemptions, the KCDPA also includes some unique carve-outs on top of the more standard privacy law exemptions. Notable examples include data processed by certain law enforcement support organizations, some utilities, and data processed to comply with laws aimed at preventing methamphetamine production. So, taken together, if you thought Indiana's law was business-friendly, Kentucky's law is arguably even friendlier. It's especially true when you factor in its higher practical applicability threshold. If these laws are not your company's very first exposure to U.S. privacy regulation, they're probably not going to be the ones that will keep you up at night. There's a strong chance that an existing U.S.-based privacy program can be extended to cover these requirements without a massive amount of additional effort. All right, there's one final state privacy law going into effect on January 1st. It's the Rhode Island Data Transparency and Privacy Protection Act, or the RIDTPPA. Rhode Island has the lowest primary applicability threshold of the three states at 35,000 consumers. However, because the state's population is so small, the threshold ends up being one of the highest proportional thresholds in the country. It's equivalent to roughly 3.15% of Rhode Island's population. Rhode Island's law is not as business-friendly as the last two, but it's also not the strictest state privacy law on the books. It really sits somewhere in the middle. On the business-friendly side, the law does not require support for universal opt-out signals, and it does not include the same type of data minimization requirements that we tend to see in other states. In that sense, it's almost the polar opposite of Maryland and the uniquely strong minimization obligations that come with MODPA. The RIDTPPA's privacy notice obligations are also more narrowly focused on commercial websites and ISPs, rather than being broad and wide-ranging. So from those perspectives, the law is relatively business-friendly. On the consumer-friendly side, the law defines the sale of personal data broadly in a way that goes beyond purely monetary transactions. It also includes very specific disclosure requirements relating to data sales. Many state laws require businesses to disclose the categories of third parties with whom they sell personal data. Rhode Island goes a step farther. Businesses must disclose the actual specific third parties with whom personal data is sold or may be sold. If you're operating in Rhode Island, that's a pretty unique requirement to keep in mind that you may not have to account for elsewhere. Penalties also skew relatively high, up to $10,000 per violation, and there is no cure period. Rhode Island appears to be taking enforcement quite seriously, which is another way that it differs from the more business-friendly approaches that we see in Indiana and Kentucky. All right, with the 3 new laws covered, let's move on to a couple of privacy law amendments, including an important one that's scheduled to take effect on January 1st. The first thing you should know about 2026 privacy law amendments is that there are going to be at least 4 of them taking effect this year. I'll give you a quick summary. Oregon is banning the sale of precise geolocation data and miners data starting January 1st. Virginia also has a VCDPA amendment going into effect the very same day. It can be helpful to think of this one as a children's social media safety law that's effectively been baked into the VCDPA. Next, in July, we'll see a very substantial amendment to the Connecticut Data Privacy Act take effect. This amendment contains a wide range of provisions relating to thresholds, applicability, sensitive data categories, consumer rights, and more. I'm not going to cover this one today. I'll likely do a separate video another time before it goes live. For now, just know that Connecticut is significantly strengthening its law later this year. Finally, we have one more amendment. Utah is adding a right to correct. So for the purposes of this January 1st themed video, and focusing on amendments that affect general privacy programs, the one that I want to spend time on today is the amendment to the Oregon Consumer Privacy Act. Under the amendment, the sale of precise geolocation data is prohibited outright. This applies regardless of consent, and it applies to all consumers, not just children. So, if your business model involves monetizing location data, or sharing it with data brokers, or using it for targeted advertising in a way that qualifies as a sale under Oregon's broad definition, those activities will need to stop for Oregon residents as of January 1st. It's important to understand what Oregon means by precise geolocation. The term refers to data that can locate an individual within a radius of 1,750 feet. Think GPS coordinates, mobile app location data, or anything else that can reliably pinpoint a user's location with that level of accuracy. The second major component of this amendment focuses on minors data. Oregon is expanding protections for children and teens by restricting the use and sale of personal data belonging to minors under the age of 16. The sale of minors data, much like precise geolocation data, is completely prohibited. The use of that data for targeted advertising is also entirely banned. From a compliance perspective, this creates 2 immediate considerations. First, companies need to understand whether they collect or infer age, and ultimately whether minors are using their services. If minors are in scope, data sales and certain forms of data sharing become far more limited and in some cases prohibited altogether. The practical takeaway is that January 1st is a firm operational deadline. In reality, companies probably should have already been assessing their data flows involving geolocation or children's data to ensure that they're not being used in ways that Oregon will no longer permit. While we're on the subject of Oregon, this feels like a good time to mention that Oregon's right to cure is expiring on January 1st. Until this point, a 30-day cure period has been available, allowing businesses to address violations before facing enforcement penalties. That cure period is now about to sunset. This change is not a part of the amendment that I've been talking about. It was included in the original law. This just felt like the natural place to mention it. All right, we've covered the new laws and at least one key amendment. Now, let's turn to universal opt-out mechanism requirements that are going to become relevant in 2 new states in the new year. One interesting trend in modern privacy laws is that certain requirements are sometimes delayed beyond the law's initial effective dates. We see this most often with provisions relating to universal opt-out mechanisms. For example, both Delaware and Oregon already have comprehensive privacy laws in effect. In both cases, those laws include universal opt-out mechanism requirements that are now scheduled to take effect on January 1st of 2026. If you're not familiar with the concept, a universal opt-out mechanism is a browser or device-based signal that automatically communicates a consumer's decision to opt out of certain data processing activities, such as the sale or sharing of personal information, without requiring the consumer to take action on each individual website that they visit. State privacy laws generally fall into one of 2 camps when it comes to automated opt-outs. Some states require businesses to honor universal opt-out mechanisms for the sale and sharing of data, and others do not. It's roughly a 60-40 split, with the majority of state laws including this requirement. So don't be misled by the fact that all of the 3 new January 1st laws don't require universal opt-out support. This is still a very significant compliance issue across most of the states with privacy laws. One interesting wrinkle is that most states have not explicitly identified which opt-out technologies need to be supported, but in practice, there's one standard that you should be well aware of: Global Privacy Control, or GPC. Global Privacy Control was created in 2020 with the goal of making it easier for people to express their privacy preferences online. It works by sending a signal from the user's browser or extension to the websites that they visit. That signal is transmitted as an HTTP header, a JavaScript variable, or both, and it communicates the user's desire to opt out of certain types of data processing. While websites may implement the signal in different ways, GPC is widely recognized as an expression of a do not sell or share preference. Under the modern privacy laws, businesses are generally expected to support automated opt-outs for targeted advertising, the sale of personal data, and certain types of profiling. So you'll want to make sure that your cookie consent platform can detect and respect GPC signals, for example, by disabling targeting cookies, although additional steps may be required depending on how your organization collects and processes data. For example, websites with login functionalities or user accounts will often need additional back-end processing to fully honor those automated opt-out signals. If you haven't already done so, now is a good time to confirm that your consent management system and your broader website can detect and respond to GPC signals, especially for visitors coming from Delaware and Oregon, given the upcoming changes. That said, for most businesses, the practical approach is simply to monitor for and honor GPC signals nationwide. This is not an area where handling things on a state-by-state basis usually makes much sense. All right, for the final topic of the video, I want to draw your attention to California. California is launching something brand new on January 1st called DROP, which stands for the Delete Request and Opt-out Platform. The platform was created in response to the California Delete Act, and it represents a major shift in how consumer deletion rights are going to be exercised at scale in California. DROP is essentially a centralized system that allows California residents to submit deletion requests to hundreds of registered data brokers all at once, instead of having to track down and contact each broker one at a time. The system itself will go live in January, and data brokers will be required to begin processing requests starting in August. From an operational standpoint, data brokers will be required to check the platform at least every 45 days and then take action on any valid requests that they receive. There are 2 main reasons that you might care about this. First, if you live in California, this is a powerful new consumer-facing tool that's now available to you. It lowers the barrier for exercising deletion rights and should make it easier for you to have your personal data removed from the data broker ecosystem. Second, if you are a data broker, this is a very real compliance obligation. If you're not already paying close attention to DROP, you'll want to make sure that you're properly registered, technically integrated with the platform, and operationally prepared to receive and process requests. This will include having workflows in place to verify requests, delete data, and document your compliance, especially by August 1st. At a high level, DROP is probably a good example of where privacy regulation is heading. The states are no longer just creating individual consumer rights, they're building infrastructure for making them easier to exercise. All right, thank you for sticking with me through all that. I hope you're feeling confident about the changes that are coming to the US privacy landscape on January 1st. If you need help making sure that your organization is compliant with any of these state laws or with privacy compliance more broadly, Captain Compliance is here and ready to help. Whether it's managing web trackers, meeting state-level privacy notice requirements, or handling privacy requests, we work to make compliance significantly easier. In fact, if you follow our company, you'll probably notice that we're actively releasing new disclosure templates for Indiana, Kentucky, and Rhode Island. If you're already a Captain Compliance customer, that updated disclosure content will be ready within days. If you're using automatic updates, these disclosures will be published before the new year. If you'd like to learn more or you need assistance, please feel free to visit our website at www.captaincompliance.com. I'll also include the link along with additional contact information in the video description. Thanks for watching.